Mr. Brown, is that Mr. Garrison there on the screen?
Yes, it is.
Yeah.
Mr. Garrison, we're going to need you to unmute on your end there.
There we should be good, Your Honor.
Okay, very good. Thank you. All right, we'll go on the record as People versus Eric Garrison, case number 236650. The record should reflect that Mr. Garrison is present today by video from Emmett County. If I could have counsel put appearances on.
The record, Your Honor, I call back people. Larry Brown, on behalf of Mr. Garrison.
Mr. Brown, can you tell me where things are at with this file?
Your Honor, we're scheduled for a status conference today. However, this matter has been set for trial to begin on September 23rd with a final status conference on September 5th. So I'm unsure where we're at or what the reason for today is, other than maybe to update the court that he is currently lodged clearly in Emmett County Jail. He is scheduled to be released at the end of July, on July 30th. That's kind of where we're at right now. There has been an offer made in the matter. However, it's still contingent upon restitution with $45,000 and change. That's just not going to happen. So our thought at this point in time is to continue the trial.
Okay, Mr. Rolla, anything that you need to add to that?
Well, actually, I do, Judge. There was an original plea offer. Yes, it included restitution upfront of $46,722.48, which was the $45,915.60. Now with an additional fee of $806.88 that was added on. There is a situation where people have 404B evidence were the defendant convicted in this Traverse City matters, but I believe those are still pending. What is more pertinent specifically to the court's inquiry is that there was a possibility of added count 3 largely by conversion over $20,000 attempted contra MCL 7503633 bracket A bracket if the defendant could provide information to where the money went, provide a realistic payment option over whatever the court is ordering it, in other words, not upfront, and also provide truthful testimony against the co-defendant or presumed co-defendant, Mr. Kane. It's the people's understanding in order that since he has now apparently charges in 4 counties, that's not a viable option. But I wanted that plea replaced on the record.
Okay. All right, so we'll continue. We currently have a plea cutoff set for early September, and then the trial dates were later in September. So we'll continue as scheduled. Mr. Garrison, do you have any questions about how we're going to be proceeding with your case?
No, I do not, Your Honor. Thank you.
Mr. Brown, anything further that we need to address?
No, Your Honor. Thank you.
Okay, thank you, Mr. Garrison. That's all for today. The court's going to disconnect at this time.
Have a great day, Your Honor. Thank you.
Okay, People versus Deborah Wells Kibbe, case number 246680. Oh. Do we have Mr. Klaus present? Are you ready on that?
Right. Yes, Your Honor.
Okay. People versus Ryan Klaus. This is case number 246718. Record should reflect that Mr. Klaus is present here in the courtroom today. If I could have counsel put your appearance.
For the record, Your Honor, I call back people. Larry Brown, on behalf of Mr. Klaus.
Okay, this is the date and set for scheduling in this matter. Mr. Klaus, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that?
Yeah.
Okay. Mr. Brown, are there any additions to the corrections to that?
Just one very minor one. In the body of the report under evaluation and plan, it says that 5 points were scored on a PRV2 for 1 prior low severity felony. However, in the prior record on the main page, it lists felonies as 0. Just maybe it was a typo, but I think it should be 1 because there's a prior felony.
Mr. Roll.
I believe that's correct, Judge.
Okay. So is PRV two correctly scored?
It is, Your Honor. It was just listed on the prior record as single felonies. He does have a low severity.
Okay, so the court will order that that be corrected. Any other corrections?
No, Your Honor.
Any challenges to the score?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
Judge, no additions, deletions, or corrections as to the body report, no challenges as to the score.
Do you have any victims that wish to address the court?
We do not have.
Anything on behalf of the people for allocation?
Yes, Your Honor, this is a situation where it's a larceny in the building and it's a first felony, as the court calls the facts in this particular case. Mr. Klaus apparently has very significant substance use problem. His poison of choice is apparently vodka, which he stole numerous times from family there. He wasn't charged as a retail fraud third, that actually probably been a higher offense, 5 years he did it as a larceny in the building. There's restitution of $198.85 for the bottle caps, the locking caps that apparently the defendant took along with the vodka bottles because they were found behind his home. This is his 10th offense as indicated in this PSI. Fires under numbers 1, 3, 4, 5, 6, 7, 9, 10, and 12. And his last retail fraud is 9th theft offense. He received 30 days on it. He should not receive less now. The recommendation is 11 months for Calvin days from the 90 days credit. People don't feel that that sends the correct message. I also would, whatever the courts can do, and I'm sure probation can do it, but make sure that Mr. Klaus gets some help with substance abuse situation. Thank you.
All right, thank you. Mr. Brown?
Thank you, Your Honor. Mr. Rolla is absolutely correct in speaking with Mr. Klaus. He does have a very bad substance abuse problem. He is working actively on that. He actually does have full-time employment. He is working at Taco Bell. That seems to be working out successfully for him. He did get some substance abuse treatment in April, and he detoxed at Bear River, and then he went to Sacred Heart for some inpatient for about a month. He does report to me that he is being sober. I think from his appearance, he appears to be doing a little bit better here as far as his demeanor and actions go. He's trying to get into CMH to get the help that he knows he needs. He suffers from anxiety and ADHD, and my guess is, given some of the things going on with his mental health, he was self-medicating with alcohol. Clearly has not worked out very well for him, and he fully understands that. He has stable residency here. I would ask the board to take those things into consideration, and I would ask if the board does want to impose any jail time, I would ask for follow that recommendation and even perhaps make it a term of his probation that he has to test, whatever work would deem necessary, or even that he has to continue with any kind of mental health treatment or substance abuse in lieu of any incarceration, which in the long run, I don't think is going to benefit him, and which is not going to benefit society.
Mr. Klaus, anything you want to say?
Yes, this job I got about 2 weeks ago, and I know if I go to jail, I'm going to lose it, and I'm gonna have no income at all, so I'll have no way to pay the courts or anything. So, just if I could do the probation, I would be there every day. Make sure I do everything that's ordered from the court. And I apologize for the inconvenience to the court too. But yes, I've had trouble getting a job, and I finally got one, and I don't want to lose it.
All right, you did read through the report, familiar with what happened in this case. I'm also familiar with you and your background and your history through the information in that report. And yeah, Mr. Roll is right. You got 9 prior theft offenses, whether it's retail fraud or other theft-related offenses, larceny, breaking and entering. Been on probation 6 times previously.
Yeah.
I'm not going to keep putting you on probation, right? Because you just keep committing theft crimes, probation has not been effective at all. So I'm not going to keep putting you on probation. I don't think that's a wise investment on behalf of me at this point. You've been given so many times through probation, get a hold of your problem to correct your behavior. You fail to do that, you continue to engage in the same behavior over and over again. I looked through your jail stays, your previous longest time in jail has been 90 days. The jail time also hasn't seemed to have done anything to correct your behavior so far. But you know, we kind of follow a principle of progressive discipline. You know, we start with lower penalties, and as you continue to do the same things over and over again, those penalties increase. And that's where we're at this point. Guidelines are 0 to 11 months. I'm going to sentence you to 6 months in the Otsego County Jail. If you're able to get into some kind of residential program and find a bed, I would allow you to be released from jail to serve out your sentence as part of a residential treatment program, because I do think that would be beneficial to you. Because I agree, I think a lot of this is related to underlying problems that treatment could help you with.
Yes.
But outside of treatment, I think there needs to be a punishment component here so that you understand that as you continue to commit these theft crimes, your penalties are going to go up.
I have one more question. Is there any way I could get 1 day because I get paid tomorrow, and is there any way I could get 1 day just to get like my financials and I will turn myself in tomorrow?
Yeah, I don't allow that. When people are here for sentencings, they need to report immediately to jail. When I give people time, bad things tend to happen. So the court is going to sentence you to 6 months in the Otsego County Jail. Again, the court would allow you to be released to a residential treatment program if you're able to find a bed and get into a treatment program. You do have credit for 9 days served. The court is going to order that you pay crime victims assessment of $130, court costs of $325, attorney fees of $350, $68 state costs. That's in addition to the restitution. And Mr. Rowland, can you tell me about that amount?
198.85.
198.85. That's payable to the Otsego County Clerk to be dispersed to the area. You do have the ability to seek an appeal of this sentence.
Your Honor, he assigned that acknowledgement. I'm to read that to the court. Yes.
This is the normal pin, 0905.
Ron, do you have any of your other clients here?
I do not right now, Your Honor. I just got a message from Deborah Wells. Yeah, and she apparently is stuck in traffic. And I need to message her back. She may be heading to the high school. The courthouse there.
Is Mr. Munzel, is he lodged?
Yes.
He's lodged here.
Pardon?
He's last year in Otsego.
Yes, he is.
Well, I'll ask the court officers to bring him up and then we'll Run the record in people versus Scott. 46678, the record should reflect the defendants present here in the courtroom today. If I could have counsel put your appearances on.
Thank you. The record, which on behalf of the people.
Larry Brown on behalf of Mr. Montel.
Sir, we had an opportunity to go through the pre-sentence report and talk to Mr. Brown about that. Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor, and I have no challenges to the scoring.
The record, I did receive email from Camper Brody, a support letter on behalf of Mr. Menzel. I did have a chance to review that prior to the hearing today. Mr. Rolla, do the people have any additions, solutions, or corrections?
No additions, deletions, or corrections to the body report, or challenges to the scoring. Thank you.
Do you have any victims that wish to address the court
We
today?
do not, Judge.
Anything on behalf of the people for allegations?
Just briefly, Judge, this is the first felony situation, second theft. But what far greater concern is the situation is that the defendant, as indicated, PSI stole a purse from the customer at Kohl's, the victim in this case, then traded her loaded 9mm Ruger semi-automatic pistol for controlled substances, specifically methamphetamine. When finally located, along with some stolen property, the defendant was found with over $4,000 in stolen property taken from many local establishments, Jay's, Kohl's, and then he also apparently traded the victim's cell phone for tools. He has little or no connection to Otsego County, apparently, other than having it be a place in which he can commit thefts. There's a recommendation of 1 year with 3 days credit. Leave that to the court. I would ask, of course, that the court's order specifically include, if it hasn't already been done so, that the firearm can be returned to the victim. Otherwise, it would be seized under 752. Thank you.
Mr. Brown?
Thank you, Your Honor. Absolutely no objection to the firearm being returned. Mr. Munsell is 30 years old, and generally when we get people with these kind of charges, especially this number of charges, they have a fairly extensive criminal history where it appears that he does not. A very limited criminal history. He did advise me that he does have a substance abuse problem. There were several things going on in his life at that time. He apparently had a daughter who was born with some heart problems. His best friend ended his own life. He had some troubles with his marriage. They ended up splitting up, and the way he described it is his life just kind of spiraled out of control. I think he probably increased his substance abuse and usage and just made some very, very bad decisions here, which are catching up with it. I think the letter from his ex-wife is kind of telling that he's really a good guy underneath when he is sober. The kid's missing. He does have a substance abuse issue that, as this court is well aware of, has a tremendous impact, not only on the individual, the people that are close to the individual, but also on the community as a whole. I believe that he does realize that. He knows he has to pay for that. But what he really would like, and what I would like the court to consider, again, just based on his age and his real lack of criminal history up until this time, if the court would consider some sort of a sentence fashioned in such a way that balances any kind of punishment along with rehabilitation in an effort to kind of get him back on the right track.
Thank you. Mr. Menzel, anything you wanted to say?
Yeah, I would like to say, I did actually, when I was arrested originally, I brought the police to the place of the firearm. I didn't actually have to find it, I took it to it. And there was another thing he had said, I can't remember now what it was. There was something else he had said that wasn't quite correct, I can't remember what it was, sorry. Other than that, I'd like to say, I'm sorry, I understand what I did wrong. I hope the victim understands that I'm sorry too.
I did read through the report, familiar with why you're before the court today. I also presided over Mr. Galarno's case, in Kalkaska County, the person that you traded the gun for that being with. So I have additional familiarity with the whole scope of kind of factual basis here. There's also a lot of information in that report about you, your circumstances, and your background. Of course, as I indicated, I did read the letter from your ex-wife. So I've got information covering kind of all sides of this, in addition to what you said here and the lawyers have said. You know, it sounds like there is some substance use issues here that may be partially responsible for your behavior. Just like anybody else, those substances affect how you react to situations and how you carry yourself. And it sounds like that when you're a sober person, you're much better for yourself and for your family. Unfortunately, you did engage in some pretty serious conduct here. The amount of merchandise that you stole, the firearm in particular that you took from that individual, you had a lot of options what to do when you discovered that there was a gun in that purse. Probably the worst option is trading it to a felon for methamphetamine. And that's concerning to me that your judgment was off to the point that you were willing to take a weapon and give it to someone else who is a dangerous individual, and who knows what they're going to do with that and what kind of danger that could pose to other innocent people that have nothing to do with you. And that concerns me that your judgment was that far off under those circumstances. When the court looks at the mitigating factors and what is the appropriate way to go forward, the guidelines call for up to 23 months in prison. I do think that a serious punishment is warranted in this case based on the danger that your behavior caused to the community, as well as the damage that your behavior did to businesses through the theft of those items and the individual victim in this case. The court does find that a Department of Corrections sanction is appropriate. However, there is an indication in the report that you qualify for the boot camp program. I think given your record, given your substance abuse issues that are underlying, that program would be beneficial to you. And so the court is not going to object to your placement in that program. The Department of Corrections will send me a form confirming that I'm not objecting to it, but making the record that today. That's going to allow you to be released relatively quickly under Department of Corrections supervision and allow you to participate in that program. And again, I think given your lack of serious history, given the circumstances here, that would be successfully complete that would give our community some assurance that you're going to move forward from this, not re-offend. So the court is going to, as to all three counts in this case, the court is going to send to the Michigan Department of Corrections for a period of 18 months to 5 years. Again, the court is not going to object to your participation in the boot camp program. You do have credit for 3 days served. Crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and $204 state cost. The court does not object to returning the weapon to the victim in this case. There is no request for restitution. Is that correct, Mr. Will?
That's right.
Okay. You do have the ability to seek an appeal of this sentence, Mr. Menzel. We're going to provide you with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed lawyer. Mr. Brown, just let me know once Mr. Menzel's.
He has acknowledged those rights, Your Honor, and I'm tendering that acknowledgement to the court.
Mr. Menzel, you are again in custody of the county at this time. Good luck to you. People versus Deborah Wells Kitty. 460.
Drama, yes, as well as Kippy. I think I just one more.
Ma'am, are you Megan Norman?
Yes, sir.
Okay, we're gonna call your case in just a moment, so I'm just gonna keep you on hold just for a minute, all right?
Okay.
Thank you, judges.
Can council put your appearances on in this file, please?
Larry Brown on behalf of Ms. Wells Kitty.
This is currently set for trial beginning on July 26th. This is today final status conference, and we cut off. Mr. Brown, have you had a chance to speak with Ms. Wells Kitty regarding the plea cutoff?
I have, Your Honor. I spoke to her a few days ago, and I just spoke to her just now. I'm pulling this file up. 1 second. There is a plea offer, although it is just plea to the charge. They won't enhance it to possession with intent. And they would also consider drug court if she believes that she is really ready for that. And I can discuss that with her again if she wishes. But at this time, I believe she is going to enter a plea to count one.
Ms. Wells Kitty, is that correct? Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you. Lower your hand. Ma'am, are you currently on any kind of probation or parole?
I'm on,
I believe she's on bond from.
yeah,
Okay, you're not on probation.
I'm on probation, yes.
You are.
I'm on a, I'm almost done, I believe. With it. It was for retail fraud, happened right during that period of misdemeanor.
Okay, you're on misdemeanor probation in Sheboygan or here in.
Actually, I believe that is here.
That's here in Otsego.
Are they aware that you're going to be entering this plea today?
No,
You understand that by pleading guilty today, that could result in a violation of your probation.
yes,
And were you on bond when this charge occurred in
No.
Sheboygan?
this happened, this charge happened first.
Okay,
I had things that happened within days or weeks of each other. It was bam, bam.
gotcha.
So it was
Judge,
pretty much.
the offense date, this is June 26th of 2023.
Okay, got it. All right, and Ms. Wells, do you understand that the maximum possible penalty you can face for possession of methamphetamine is up to 10 years and or $15,000?
I do.
With that in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights. You understand that you're giving up and waiving all of those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the Court of Appeals to hear your case. They can say no, and then that would be the end of any appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what was said here in court? Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
Okay, so as Mr. Rolla indicated, this happened back on June 26th of 2023, is that correct?
That is correct.
On that date, were you present here in Otsego County?
I was, Your Honor.
While you were here in Otsego County, did you have possession of some methamphetamine?
I did, Your Honor.
Did you know that that's what that substance was?
I did, Your.
Did you have any legal right to have any amount of that at that time?
Absolutely not, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
None by people would think.
Mr. Brown?
I am not aware, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in taking of this plea?
Yes, Your Honor.
Mr. Brown?
Yes, Judge.
As well as Kitty, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. We'll set this matter for sentencing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with Mr. DeLeo for probation to set up a pre-sentence report. And then just make sure that you stay in touch with Mr. Brown prior to that next hearing. Okay?
Thank you.
And then for counsel, the court will adjourn the trial date that's currently set for July 26th in light of the plea. Mr. Roll, anything else on this file?
Not from people this time, thank you.
Mr. Brown,
Nothing further.
I think that's all.
Thank you.
On the record in People versus Megan Norman, case number 246721. The record should reflect Ms. Norman is appearing today from Sheboygan County Jail. If I could have counsel put your appearances on.
For the record, Your Honor, am I calling down people?
Larry Brown on behalf of Ms. Norman.
Thank you. Brown, can you tell me where we're at with this file, please?
Your Honor, I have.
Gonna have to deal with this feedback.
Your Honor, I have spoken with Ms. Norman regarding this. She is currently charged with 2 counts. There is a plea offer that if she would plead to count 2 and an added count 3, which is usage of methamphetamine, count 1 would be dismissed. It is my understanding she is going to take advantage of that offer today. Pursuant to statute, I believe the taser is going to be forfeited.
What's the maximum penalty for the use charge?
1-year misdemeanor on the possession of taser. It's a 4-year felony.
Mr. Rolla, is that a correct statement of the plea offer?
It is Judge, count 2, which is a 4-year conviction. And added count 3, controlled substance use of methamphetamine. The statute is 333.74042A-8. It's a 1-year, $2,000 misdemeanor. Tasers and controlled substances are going to be confiscated for statute.
Ms. Norman, were you able to hear all of that?
Yes, sir.
And is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Ms. Norman, are you currently on any kind of probation or parole?
No.
Okay. And you understand that by pleading guilty to count 2, which is possession of a taser, that carries with it a maximum possible penalty of up to 4 years and or a $2,000 fine?
Yes, Your Honor.
And that use of methamphetamine is a misdemeanor that carries with it a maximum penalty of up to 1 year in jail. Do you understand that?
Yes, Your Honor.
With those potential penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. You have the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask the next higher court up, which is the Court of Appeals, to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said on the record here today?
No.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
The information I have indicates that this took place on April 19th of 2024. Is that the correct date?
Yes.
On that date, were you here in Otsego County?
Yes.
When you were here in Otsego County on that date, did you have possession of a taser weapon?
Yes.
Did you have any legal right or authorization to have that weapon at the time?
No, Your Honor. I didn't know that it was illegal to have it, but no, I did not.
Okay, you didn't have any kind of license or you weren't otherwise authorized to have that kind of weapon?
I didn't know that that was even, you needed to have those things, so no.
Okay. Did you also have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yes, it was an empty pipe.
Did you have any legal right to have any amount of methamphetamine, whether it was residue or otherwise, on that date?
No, Your Honor.
Mr. Rolla, are the people satisfied with the factual basis?
Yes, Your Honor.
Yes.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
Not by the people, thank you.
I'm not aware, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Your Honor.
Mr. Brown.
The court has complied.
Ms. Norman, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You have the right to have that hearing in person here in Otsego County. If you wanted to exercise that right, the court would have and would sign an order having you transported from there in Sheboygan to Otsego for that hearing. You can also waive that right and we can have that hearing by video like we're doing today. Do you know how you'd like to proceed in that regard?
I'd like to have it in person, please.
Can you say that again? I'm sorry.
I'd like to have it in person, please.
Okay, so Mr. Roloff, the people can prepare an in-person writ, we'll set this for an in-person sentencing. Also, in the meantime, Ms. Norman, somebody from the probation department will be in touch with you to do a pre-sentence interview, okay?
Okay.
Mr. Roloff, anything further on this case today?
Thank you.
Mr. Brown?
Nothing further, Your Honor. Thank you.
Ms. Norman, do you have any questions at all?
When am I being sentenced? What date? Or you don't know yet?
We don't know the date, but you'll be given a written notice of the date and time of that hearing.
It should be around a month or so.
Judge Bartolomé, the record, Mr. Brown or his client know how long she will be in Sheboygan, so we'll know if it's gonna be at the time of sentencing.
I mean, she's gonna be there for a while.
Very good, just wanted to verify that, so we don't have to do a situation.
All right, that's all for this hearing today. Ms. Norman, the court's gonna disconnect at this time.
Thank you.
That also concludes our docket for today.